Yes.
With my left handling, I permitted to mention a matter, assigned matter, that for extension of intermodal is going to expire on 16. It is happening in the monthly list under the heading hearing, my lord, as item number 440, my lord.
And when was it assigned?
Assigned, my lord, it was taken up once, taken up for hearing by your lord.
Yes.
It was released by Honorable Justice Zito Goto through that bank.
Whatever.
My lord, once it has been taken up for hearing by your lordship, extension of intermodal was extended by your lordship till 16th March, my lord. It is expiring on 16th March, any date before 16th March, my lord. Or my lord, monthly
Lordship may allow to mention for upgradation, Lordship, monthly list item number 93, Lordship. The petitioner, the agency is the petitioner had applied for the post of constable in CRPF. His name is appearing in the final merit list published in January, but till date he has not got any appointment letter, and the recruitment process will be over on 11th of March. 11th of March, yes, yes, Lordship. All right, give the number.
And may I have the kind to mention, my lord, for application. And this is that, my lord, the petitioner was issued an order of transfer in violation of the guidelines of the service rules. I made representation, I asked to make representation. Without causing the same, they are now.
Oh, but the transfer matter, no upgradation, sorry, no upgradation. No, sorry, yes.
My lord, I'm praying for
Inclusion as motion.
No, it's in motion stage almost. It is a 9 years old matter.
Yes.
Third round of litigation and
it is a 9 years old motion.
no, not motion.
Then it must be hearing.
After round of
The round is not important. What is the stage? Hearing. 9 years, how can a matter remain as?
this is apparently appeared to be 35, but once restitution allowed, appeal has been dismissed and contempt has been done. Thereafter, order has been sought. Division bench refused to.
Whatever. Just check if it is motion, then it is alright, otherwise do not give. Yes, sir.
To mention a matter for inclusion under the heading of new motion, this matter appeared on the last occasion since the principal respondent of lordship had not appeared. They were directed to serve a notice and come back. The matter was returnable in December 9. Somehow matter did not appear. Then I'm saying for inclusion of
original side hearing matter of 2024 urgency is the non-payment of retired dues, my lord.
Give.
Then very permitted to mention over item number 301 of the lordship's monthly list of March. That I'm paying for upgradation. That urgency is that the petitioner has been temporarily transferred to Bangalore in August 2025 by his Honorable Justice Lordship, and since then he is working there. Although there is very problem in his family, which for that reason, my lord, an early hearing.
Transfer matter, I will not upgrade.
My lord, may be permitted to mention, my lord, this is the upgradation of item number 6, my lord. This is relating to family pension matter, my lord, and petitioner is suffering from renal failure patient.
My lord, is a new motion, my lord. On 2nd February move, today is the date for appear. But due to change of determination,
We have the lordship's kindly.
New motion, when was it filed? It has not appeared. Give.
One is 2017 manner. Both has not appeared.
And 2017 matter will be a motion?
Yes,
It was never taken up earlier? What were you doing from 17 to 26, nearly 10 years? You didn't take any steps?
that was
Assignment?
no means it is not. I am not the advocate of record that matter.
So what? You are mentioning a matter you will not know as to why for the last 10 years the matter is still at the motion stage. Alright, you give, I'll see.
May I have the lordship's kindly.
Order was passed by whom?
Honorable Justice Sugata Bhattacharya, my lord, for dismiss for default, my lord. Due to illness, I could not able to appear. That's why matter was dismissed.
Under which group? Matter is under which?
6, my lord.
Alright, give. Yes,
Deeply appreciated.
My lord, in the month of February, my hearing matter by lord was listed. Well, in the monthly list of 392 February, change of determination by matter not in the list. Thank you.
and for inclusion of list matter, which are forms are considering the not the state transfer corporation.
Give. Give.
One, 2014 and 2024, all are.
2016 matters still more. 26. Give. So many. Three matters. But then notice should be served upon the other side. Yes.
But this is my relation to the recruitment, the post of our center on to the.
What do you want?
But that had to appear, it was the case in this valid to the person we could say the share relation part. So much is there. What is kind of
Give. Yes, sir.
Three matters, my lord. This is their share and intent law. These are already passed orders. I will prefer the senior order. Senior order because.
And then similar order by some other honorable judge. I have to see. Alright, give. Give. Yes, sir. Give. Yes.
My lord, this is hearing matter. I mentioned this matter on 2nd March. Worship directed.
But hearing, there are quite a few hearing matters on the list. I do not know. You give the number, I'll see. Yes.
Lord, I am praying.
Give.
Using the list, my lord, the matter relates to my lord appointment on compassionate ground, my lord. My lord, pursuant to order passed by the Honorable Justice Ropita Banerjee, ossification test was conducted. Thereafter, my lord, the SSK filed a report. The report is in the record, my lord. Only, my lord, that report is also in my favor, my lord. Only the order needs to be passed, my lord.
Who is your other side?
My lord, Coal India Limited. Coal India Limited.
Colin, whether some learned advocate must be there.
I will inform my lord, Mr. Manik.
Alright. Urgent motion.
And my lord, only for one motion for
Give.
My lord, this is new motion.
Very original side hearing matter, milady.
Give.
Application.
Application.
Yes.
Why application and not the
Amendment of the repeat.
amendment of the writ petition?
There's something as a mission.
Something is missing.
Document had not been served upon me.
Served upon you.
No, when this matter I moved before your lordship at that time, in the year 2019, they are not served it. Now they are serving me, that's why I paid for.
And that is the reason you file an amendment application. Anyway. Application, it will appear as application.
May I be permitted to mention one application much?
For what?
Application for payment of retirement.
The motion and the matter, the main matter?
Main matter is pending lawsuit and the respondent has categorically stated that a portion of amount which is in my favor lying with them, they are willing to pay it back.
Admitted amount?
Yes, in spite of that, they are not paying.
I will give.
Yes, ma'am.
My lord, I have a lordship's, my lord, leave to mention a very urgent matter, my lord. The selection is scheduled for tomorrow, my lord, 10th. My lord, an application.
Selection for what?
My lord, the selection for the post of inspector in the RPF. In the RPF, my lord, kindly, my lord, lordship will kindly.
Tomorrow, when did you file it?
My lord, this was filed, my lord, 1 month back because it was rotating in different courts. We were trying to mention.
Tomorrow, how will you have to serve your other side?
My lord, I have already served. I'll again serve, my lord, lordship.
Serve.
I'll do that, my lord.
If it is possible, not possible tomorrow, then day after at least check up.
Lordship, may I be permitted?
Urgent motion.
May I be permitted?
Yes, sir.
Upgradation. Petitioner is a retired employee of SLST.
Not getting the terminal dues.
Not getting 120 days of leave salary.
Alright. Give. Yes. I took your mentioning. No. Sorry, rationing. Nothing doing. No, sorry.
Pensioners, 2005 pensioners retired by its employee relation. Each year this 2028 recalling policy was brought in. They were deprived with the benefit of service CPC. They were pointed with the liability of 20 This is the 2028. Only short point.
2020 read petition. Wait, come in the next day. Yes. Motion. Give. Give.
For restoration application.
Restoration. Order passed by which court?
Court number 2.
And is it a group 6 determination? Give. Yes. Application for inclusion. What is the application for? Dismiss for default, give. Yes, sir. Non-prosecution, give.
May we permit a motion for
Non-prosecution,
motion for inclusion. It was appearing on the monthly list of February, my lord.
give.
My lord, may I have your lordship pray for upgradation of your lordship's monthly list item number, my lord, P41, my lord. It was filed, my lord, taking leave of your lordship's, my lord. But since the state did not appear, I was directed to serve another notice, my lord. Since then, the matter is pending, my lord. Matter pertains to, my lord, dismissal from service, my lord. And only praying for an interim order with a contractual employment. If someone is employed, my lord, engage in his place, my lord. This petition becomes, my lord, infectious, my lord. Your lordship kindly consider, my lord.
Terminated employee
Yes, madam.
and you are seeking interim order. Is it possible?
My lord, just abide by the result of the petition.
That it goes without saying, but then no.
Right.
Where is the matter now? It's there in the list. Let it remain. Yes, madam.
I am paying for inclusion the matter for motion.
Motion. When was it filed?
2023.
Motion still now. Why? 3 years, 2 years. What was happening with this matter? Where was the matter now for so many years? No idea. Why? You should come ready. Give.
Same as.
Yes.
May we permit to mention the original side hearing matter, no, all affidavit.
Matters are there. Madam, how many matters are there? In, you did not say 6? 7 matters. All same.
All same.
What is the matter about? No idea. Next time, please come prepared. Yes.
May we permit to mention the original side hearing matter, no, all the affidavits are complete, a very short.
Give.
My lord, my lord.
I heard just now.
Yes,
Why?
second round I have.
No second.
Pensioner matter. Police. And the police recruitment.
Under which heading will it come? Don't know. Get ready and come back. All right. Yes.
Item number 2 to 9 of my lord is the petitioner, my lord, paying for one of the interest on the overdrawn amount. Similar employees, my lord, the amount has been reduced.
Interest or overdraw, just wait.
My lord, kindly
Yes.
to mention. My lord, this is two conjoined matters for inclusion for hearing related to unlawful termination of paramedical workers under the National Eradication Scheme. The
Right
termination
now, no.
done by-
Right now, no.
My lord, it's a small issue, my lord. It is covered by division bench judgment, my lord.
Just wait. Yes.
Item 345, my lord, for upgradation, my lord. The petitioner is in service in the government hospital. He is a doctor. From 2007, all along, he is in private practice in addition to his service, my lord. 2025, government has issued a notification who are in private practice, they have to obtain fresh no objection. Accordingly, application was made, but such application was rejected without any reason.
That means you cannot practice privately. No.
My lord, two group 6 motion, my lord, I'm praying for inclusion.
Stage.
Motion, my lord.
When was it filed?
My lord, one was in 2024, one in 25.
What was happening for so many days?
It
like
was
that?
listed, my lord, it was running in the list, my lord, as it is. My lord,
Then how did it go out?
my lord, because it's a determination, my lord, it went out, I guess.
Usually it doesn't happen anyway. Give.
Oblige, my lord.
Yes.
For inclusion of restoration application, my lord.
Give. Motion. When was it filed? 86. Give. It will appear automatically.
According to membership, this matter was listed in the file. Also start hearing parties and
Which group it is?
6 motion.
Sure.
Yes, we have made the listening corrections.
Give. Give.
Group 6 hearing matter 2013.
Anything remains?
Yes, my lord.
What?
2 acres of the petitioner's land had been acquired in lieu of employment, my lord. There's something still there.
Please wait. Yes.
Your Lordship, may be permitted to upgrade 3 matters, Your Lordship. The Honorable Supreme Court set aside the first SLST 2016 and said untainted candidates resume their previous job. But the
SLST.
yes, Your Lordship.
Which group matter?
Group 6, Your Lordship. It is not education. The concerned respondent is bank, Your Lordship.
Bank.
Yes, Your Lordship. Did not allow me to join. The Honorable Supreme Court has directed to an untainted candidate can resume their previous job.
In the bank also untainted candidate.
No, Your Lordship. the petitioners were appointed as an assistant teacher, but the whole panel, first SLST 2016, was set aside, and the Honorable Supreme Court directed in the judgment that the candidate who is not found to be tainted candidate, they can resume their previous post, and they were previously appointed was in the bank. They were
Now the bank is not
No.
permitting you.
yes, Your Lordship.
Bank is not permitting you.
Yes, Your Lordship. Did not allow me to join.
All right, give.
Grateful.
To mention two matter, Your Lordship, my lord. First one is for correction, my lord. Order dated 12th February 2026, transfer matter, my lord. For correction, and my lord, one matter for inclusion, motion matter.
Which group?
Group C.
Motion?
Yes, my lord.
Which year matter?
My lord, 2025.
Give.
Dateful date.
On restoration application, I can give.
Give.
Inclusion the daily motion, my lord, inclusion. Group 6 matter, my lord.
Motion?
Yes, my lord.
When was it filed?
26, my lord.
26?
It was written on 5th of March, my lord, due to change in economy.
Give.
My lord, it's the same. This matter is covered by a division bench judgment where they had directed that sound reasoning has to be given for
Sir, please come next time when I take mentioning matters. Yes.
For inclusion.
Inclusion and the.
Okay.
When was it filed? Very well, give.
I think permit to mention a matter, my lord. This matter has been filed challenging the manner in which the seniority list is being published by all India, Your Lordship. My lord, the matter is ready for hearing. My lord, the urgency is, my lordship, some steps, coercive steps are being taken due to the pendency of this litigation, my lord.
You challenge seniority list
Yes.
and coercive matter is taken. Both will be same.
No, my lord. Because of the pendency of this litigation, my lord, the management is somehow, my lord, pressurizing and, my lord, attempting to, my lord, setting to attempt, my lord, for transfer. My lord,
That is a fresh cause of action.
That's absolutely, Your Lordship. My lord, kindly
Nothing.
take up the, my lord,
Yes,
Your
please.
Lordship, may be permitted to mention one matter for upgradation. It's appearing in the list as item number 387, Your Lordship. And the urgency is the petitioner was working in the state corporation, Kolkata State Transport Corporation, and before retirement, he has not been paid his salary for more than 24th month. And
24 months.
Yes, amounting of more than 13 lakhs, Your
Yes.
Lordship. And he is
When did he retire?
he retired in the year 2023.
Huh?
After that, he made several representations before the concerned authorities, but no action has been taken.
This is your grievance.
Yes,
Is this your grievance?
yes, Your Lordship.
Did you get your terminal benefits? You do not know. Give. Yes.
For inclusion, group 6 matter, hearing stage.
Hearing, do not give now.
For inclusion for motion, Lordship, group 6 matter.
When was it filed? 24. Motion still now.
And
Direction for affidavit was not given.
appeared in a monthly list of February, Lordship, with being analogous matter, Lordship.
When analogous matters, where are those matters? And was any order passed for hearing the matter analogously?
The order both the relevant matters will be appeared under the heading motion in the monthly list of May of 2025, Lordship, but thereafter the matter has been.
Give.
my lord, permit the inclusion in the list, my lord. This is, my lord, service matter relates to, my lord. This is in new motion, my lord, and the matter is related to, my lord. The matter is pending before the Honorable Justice Arinda Mukherjee, and thereafter, my lord, changing the determination. The matter is came before the, my lord.
For inclusion 225 matter,
Motion?
yes, Lordship. Affidavit 6.
My lord, only urgency, my lord, that next month, my lord, the seniority list will be published, my lord.
Doesn't matter.
My lord,
Yes,
kindly.
my lord, may be permitted to mention for correction, ma'am.
Give.
May I permit to mention a matter?
Contempt application. Give.
May I permit to mention a matter for inclusion for hearing? This is a compulsion appointment matter. Petitioner is illegally.
This matter is to be heard.
Yes, my lord.
Hearing. Opposition was given.
That is, I don't know, my lord.
You inquire and then come.
Your Lordship, contempt application for inclusion, if Your
Give.
Lordship permit. My lord, may I be permitted to mention a matter? This application is in motion stage, my lord. This is regarding a service matter and for the suspension. My petitioner was suspended in 2024.
When was the matter filed?
It was filed in December, my lord.
Last year?
Yes.
Give.
Lordship, this is my service. Lordship, this is a monthly list in 341. I am paying for upgradation. My lord, this is the termination issue and it is remaining.
Sorry, termination cannot be upgraded.
We need to mention two matters for inclusion. These are motion matters. My lord. Let us go.
Call the list, please.
Lordship, may I be permitted to mention a matter, one contempt application, Lordship.
Pass on the number, please.
Lordship, may I be permitted to mention the item, case details in the chat box?
Not today. Yes, please.
Thanks for the petition.
My lord, I am appearing for the respondent. Which respondent? The ECL authority. My lord, I am praying for adjournment. Why? Due to my senior could not reach now. Why? On the way. On the way, it is 11:17 on the way. The court sits at 10:30. My lord, he is coming from Barasat. So what?
Next week, maybe.
Next week?
Because election is also, my lord, going on, my lord.
Are you contesting?
No, but we have to be there, my lord. I'm not contesting, but my friends are contesting.
Your friends are contesting and you have to support them.
My lord.
All right. Not this week. Next. Item 2? Well, it's similar. Same. But then next time you come prepared. Do not wait for your senior. All right. You will open and then your senior will come. All right.
For the petitioner, my lord. No, two.
সিমিলার অর্ডার হয়েছিল হয়ে গেছে আচ্ছা
কবে
not this week next week not this week
my prayer, my lord, during pending of writ petition, my lord, they have rejected, my lord, I have to
rejected what
but the prayer of the petitioner
for
my lord, the grant of MMCC. Though my lord, the honorable court was directed to consider in light of the Mayabawdi judgment they have violated. So, my lord, I need to, my lord, the being before this court, this my lord, the supplementary.
No, will supplementary help you? You have to file a fresh rejection. Grounds will be different.
No, different, my lord. Can you see the my lord, the order passed by this honorable court? Representation to be considered in light of Mayabawdi judgment.
Yes.
Mayabawdi is, my lord, the settled law.
Very well. Now, if the rejection is there,
they say authority.
No, that is on merits. But your writ petition was for some other purpose, for consideration.
No.
Writ petition was for
one of the grant of MMCC.
That means for consideration of a grant.
No, my lord, subject to correction. There is a bunch of, my lord, petition. First matter, my lord Justice Aniruddha Bose laid down the law. And other matter, that honorable court was directed to consider the representation in light of Mayabawdi. Because Mayabawdi is the settled law. But they have rejected that. The pending one appeal is pending before the court. That's why we are not granted. That is, my lord, I need to. But this completely violation of this honorable court order, my lord. That's all. One matter last week, lordship has, my lord, grant to fix the matter on 23rd, and liberty granted to me, my lord, to file a supplementary affidavit.
So you wanted to
same. Fix on 23rd.
Right. Please come. On the prayer of the learned advocate representing the petitioner, release the matter on 23rd March. এখানেও এটা সেম রয়েছে 5
5 নম্বরটা দিয়ে দেবেন।
Liberty may be granted to file a supplementary affidavit.
Yes, liberty granted. Serve.
Madam.
Yes.
Now for the petition dispute.
Bibliographed. 20,000. Who is your other side?
My lord, copy has been served, my lord, to them, my lord.
Busy in election duty?
Possibly, my lord.
Not this week?
Not this one.
All right.
Your Lordship, I am appearing for the petitioner. Your Lordship, we have already served to the respondent. Since there is a resolution, they are not appearing. Your Lordship, I am praying kindly fix a date so that we can serve again and they can be represented.
Earlier also nobody appeared?
No, Your Lordship.
Never?
Your Lordship, they have appeared and this is fixed for hearing. We have served our objection and it is,
Who is the authority?
Your Lordship, Niladri Bhattacharya.
Authority. Bhattacharya is the advocate. Who is the authority? West Bengal Transport Corporation?
Yes, yes, yes. Yes, Your Lordship.
I can see Debolina Chattoraj, Miss Angona Datto.
Yes, Your Lordship, they have appeared before.
Can you give notice to them?
Yes, Your Lordship.
All right.
Your Lordship, we have already served by mail and through call.
Regarding today's fixing?
Yes.
You give one more notice, I'll make it not this week, come back next Monday.
Your Lordship, can it be fixed on a particular date?
Yes, next Monday is a particular date.
Much obliged.
All right.
That it has come at my instance, my lord, and for the petitioner. In this matter, my lord, even in the prayer, my lord, the petitioners accepted that commission is not accepting any EWS certificate, save and accept continuous EWS certificate, my lord. At paragraph 4 and 5, my lord, it has been recorded that specific stand of the commission is that reservation certificate issued after July 21.
All right, paragraph 4, 1, please come.
4 and 5, my lord, after.
Also, as we can make clear, not accept any certificate issued after.
Just one humble submission, my lord. If your lordship is just recording submission, my lord, kindly records the same is under the same issue is under challenge, my lord, and my lord, that's all, my lord.
See, this is only for correction. If it is under challenge before some other court, let it remain.
Well, it was challenged before your lordship's court, my lord. Affidavit directions have been made. Affidavits have not yet been completed.
That is a different issue. There is a different bench the court will take up. All right. That will supplement the list for list at the instance of the learned advocate representing the commission. Stuff. It has been submitted that the stand of the commission is that reservation certificates issued after July 2021-2025, July 21, 2025, will not be considered as a valid document except the continuing ones, right?
Yes, except for continued EWS candidates where applications were made prior to 27-2025.
Except continuing candidates where applications were made for grant of EWS certificate prior to July 2020, July 21, 2025. Yes, sir. Let this paragraph be added in the order dated 23rd of February 2026. As paragraph number 5A. Next.
When the time for the petition.
Respondent bank? Yes.
The matter was appearing in the list. At the bottom of it. Suddenly it matter anyway, madam. Case of department.
My lord, I served them the notice. This is the notice, my lord. I have. My lord, the issue is that the petitioner is ex-employee of the armed Air Force. Then he was re-employed in SBI Bank, my lord. The Defense Ministry have issued a DA on after retiring from Air Force, my lord. But the bank suddenly stopped his DA allowance without any further notice or anything, my lord, from 2014. And when the petitioner was retired on last June, then his DA was again start, my lord. But the central government notification is there, my lord. Circular is there. Below officer rank, the DA should be allowed to the petitioner, my lord. Several bank has given this, but the SBI has stopped it is illegally, and a huge amount was spending as a DA, my lord.
Did you write to the bank for?
My lord, I have write the annexure. I have write, my lord, and last notice. What are the CO. This is the last, my lord. The petitioner has a right, and several notice has been annexed with the petition, my lord.
Notice.
Notice नहीं होता.
I can see at page 17, there is a communication made by the bank to you, which mentions that the DNS allowance and defense pension. You are not eligible to get
pension and always the DA, my lord. Circular to do 200. My lord, this is the circular issued by the central government defense ministry, my lord, where it is clearly stated that below officer rank is eligible for the DA, also the pension, my lord.
And what is the rank that you are employed in?
My lord, I am employed as a I am not an officer, my lord. I am as a Sipahi, my lord. Below officer rank I have.
Below officer rank?
Yes, my lord.
Posts below Group A and those ex-servicemen who held posts below the rank of commissioned officer at the time. Enter is to be ignored. When it's to be fixed in there.
Not kindly see
such pensioners will consequently be entitled to DNS allowance relief on their pension. So you only want DNS allowance?
Yes, my lord.
which was
For the period you were re-employed.
yes, my lord, from 2014 to 2015 June, they have stopped my DA, my lord, without any reason. And after my retiring from the bank, they have started my DA
Yes,
again.
that is what the communication says. All right, let me hear.
They are getting pension, they are getting
Pension?
pension, that the DN is the DNP, that component is there. Then, my lord, lot of cases filed across the country. So you remain states. Not only this, there are other things, MSP, BD service, etc. Then the bank went to the Supreme Court. So all the matters have been transferred to one court. The Supreme Court considered as a review. Lot of cases are there, so it will go through from the Punjab and Haryana High Court. That all the cases, this is about all went to the. This judgment also applied at the deposition. 2009 to 2025 it was. We withdrawn the reputation from the that court. These are the same prayers. Because nobody got who DRDs really cannot be taken if he is fitted in a with pay protection. If the minimum is fitted, then DRDs will be given. But pay protection is given, then he cannot get the twice people. In bank he will because the PA and in the pension will be that is not participate. After retirement, he can get. That pension will get, this pension will get. Now, my lord, this is the requisition is filed there earlier in this high court, and then it will transfer to the Punjab.
It was filed here, it was transferred there. He withdrew. Yes, now he withdrew it from there and he filed here afresh. He withdrew it from there and he filed here afresh. All right, yes.
So therefore, my lord, is written by FSI, it's not better.
What happened to the other matters which were pending before the Panchar?
The matters are disposed of in 2023. Nobody has pursued for DA, they pursued for MSP.
All right.
It was rejected by the Supreme
All right.
And now it's set at rest for 2023.
But my lord, other bank has paid same with PA, and I have some my close relatives are there who has served as Navy officer, my lord, working in PNB. Right now he is in service, but he is similarly pays. But all the
Did you disclose the fact of filing the earlier writ petition in the year 2013? Then the matter went to Punjab and Haryana High Court.
My lord, that was my mistake. I have
mistake. How can it be a mistake? This is
my lord, I have not informed on that time.
Withdrawal is there.
On the self-same cause of action, if you have filed a writ petition and withdrawn it, how are you entitled to relief? Please let me see. Vinay Krishna Bala.
That petition was renumbered there 10124, page 5. Remember the 1012.
Sir, are you aware that an earlier writ petition was filed?
My lord, after filing this, when I have mentioned and I have talked to them, then he was informed me, my lord.
In that case, your client has tried to play fraud upon the court.
Yes.
Please come. The petitioner is an ex-serviceman Serviceman. Petitioner, yes, he's an ex-serviceman. After retiring from service, he joined the State Bank of India. Stop. He is aggrieved as DNS allowance for the period 2013 to 2025 was not. He is aggrieved as DNS allowance for the period such and such was not granted to him.
So
the instant writ petition has been filed directing the bank inter alia directing the bank for grant of DNS allowance for the entire period 2013 to 2025 together with interest. Stop. Learned advocate representing the State Bank of India submits that on the self same cause of action, the petitioner filed a writ petition before this court earlier, being WP number 38010 within bracket W of 2013. Stop. The said writ petition was as per the order of the Honorable Supreme Court. Supreme Court's order. Do you have that order? Supreme Court, the writ petition stood transferred to the Punjab and Haryana High Court. And renumbered as CPW number 10124 of 2021. Stop. The said writ petition was withdrawn by the petitioner on 2nd August 2022. Stop. Paragraph, it has been submitted that fresh writ petition over the self-some cause of action will not be maintainable. Stop. Paragraph. The order of the High Court of Punjab and Haryana dated 2nd August 2022 passed in CPW number 10124 of 2021 has been placed before this court. Stop. The writ petition on which the order of withdrawn was passed has also been placed before the court. Stop. It appears that the prayer made by the petitioner in the earlier writ petition is similar to the prayer made in the instant writ petition. Stop. The earlier writ petition stood withdrawn without obtaining any leave to file fresh writ petition on the self-same cause of action. Stop. In view of the above, the subsequent writ petition on the self-same cause of action will not be maintainable. Stop. The writ petition fails and is hereby dismissed. Learned advocate for the bank submits that the writ petition is liable to be dismissed on the ground of suppression of material facts. Paragraph. On a perusal of the documents placed before this court by the learned advocate representing the bank, it appears that the fact of filing the earlier writ petition was actually suppressed in the instant writ petition. Stop. Such conduct of the petitioner cannot be appreciated. Stop. The suppression has to be taken as deliberate and fatal in the instant case. Copy of the writ petition being WP number 38010W of 2013 and the order dated 2nd August 2022, passed in CPW number 10124 of 2021. Handed over in court today by the learned advocate representing the bank, be retained with the records. Return this circular, affidavit of service and the notice of hearing be retained with the records. Next.
Deeply obliged, my lord.
After the petitioner, my lord. In this restriction, my lord, the petitioner applied for the post of recruitment for the post of GD in Central Armed Forces, Assam Rifles, and others of 20.
Are you there for the respondent?
My lord, the recruitment process consists of written examination, that is computer-based examination, physical test, and thereafter medical fitness, medical test. Now, the petitioner qualified in the computer-based examination, in the physical test, and the medical test. My lord will kindly take page 62. This is the medical examination report where I was found defective distant vision, both eyes, and squint. Thereafter, I consented for review medical examination. Just the next page, my lord, page 63, where I was declared unfit once again for mild squint in left eye. Thereafter, my lord, I visited Nadia District Hospital. There I was declared that I have no squint in my eye. Even then, my lord, I approached the AIMS Kolani. AIMS Kolani also found me orthophoric, that is, having no squint in eye. My lord, will kindly take page 64, the very next page, that is the Nadia District Hospital, categorically observing that there is no squint. The review medical examination was held on, my lord, 26 November 2025, and I visited District Hospital on 29th November. And thereafter, my lord, page 67 is the advice of AIMS.
Where is the CAPF report? Your medical standards?
Yes, my lord. My lord, in 2000.
Not qualified, final result. Not qualified in the. Where is the medical examination? Bit 2.
Page 62 is DME, my lord, and page 63 is review medical examination.
62 defective distant vision. Squint. There are two, isn't it? Defective distant vision as well as squint.
Yes, there was two. In review medical examination, they differed. They said not only, they said defective distant vision BE, that is both eyes, my lord. In detailed medical examination.
Defective distant squint.
And squint.
Page 63 also it is the same thing.
Page 63, they omitted now defective distant vision. There is only mild squint LE, left eye. It changed.
Yes.
Thereafter, my lord, I visited a government hospital, Nadia District Hospital. It said no squint, page 64. And AIMS also observed there is no squint. My lord, the Honorable Coordinate Bench directed the respondents to
file a report.
Report has been filed. In the report, my lord, they have relied on 2013 guidelines for detailed medical examination.
Yes.
Yes. On that, my lord, they have referred to certain pages. That is page 6 of their report. They have referred to general grounds of rejection. Well, this entire report I have already annexed to my writ petition. I'll show, my lord. 6 and subpoint 6 at page 6, my lord. Any degree of squint is ground for rejection. My lord, there is no squint and I was declared unfit. And not only that, my lord, they have relied on this. They have marked this with a tick. If my lord kindly takes up now from my writ petition, I'll show this guidelines that they have referred, my lord. This is the 2015 13 guidelines. which is the guidelines for TM 2015. Thereafter, there is also a guidelines for review medical examination that came in 2021. I refer to that one. In my writ petition, my lord, page 71 is a relevant page. And page 70 has the title Guidelines for Review Medical Examination RN in Central Armed Police Forces and Assam Rifles. So in this page 71, the very first paragraph, the defect for which the candidate has been declared unfit should be examined thoroughly, and the findings must be supported by proper investigation reports if applicable. But here, nothing has been done.
Without checking, you were declared unfit.
With just manual, nothing else. No report, no investigation, nothing.
No, report is there.
What type of further checking you want?
Well, when I visited the other hospitals, they have checked me with instruments and other things. Even their entire detailed guidelines show there can be other tests as well. I'm not going into that. But they consistently, DME varied from, RME varied from DME. But the two other government hospitals, one of them is AIMS. Clearly says there is no squint. How can they differ?
Anything else?
Well,
yes.
And in my humble submission, I have submitted my report. My report specifically says that the candidate was examined at BSF hospital
Where have you mentioned that?
Page 5, my lord. I'll just annexure R2, my lord. It will see the words mild squint written at the bottom, my lord.
Page 5. Yes, page 5. These are the guidelines.
The earlier page, the earlier page, my lord.
Yes.
I will kindly see this is OPD sleeve BSF hospital, my lord. At the bottom of the page, mild squint, left eye,
Yes.
LE. So this is a hospital certifying that the candidate has mild squint. And if my lord turns over the page, my lord, the next page, general grounds of rejection. This is part of the guidelines. Clause 6, subclause 6, any degree of squint. So even if it's mild, that is a good ground for rejection. That is why he has been rejected.
Please come.
well, one thing. The general grounds of rejection, they have given the truncated copy of the guidelines. That was my squint is not acceptable. If my lord kindly takes up page 83 of my read application, this is the page 81. My lord kindly check that will show my lord that I'm referring to the same document. Page 81, my lord is seeing 6.6, that is squint. My lord, I'm referring to 83. 83 in their guidelines, it also refers to C, note C. In doubtful cases, candidates would be referred to a specialist for examination and opinion.
Doubtful
examination of any other
not a
special
doubtful
investigation, test or examination.
This is not a doubtful case. This is not a doubtful case. There is a clear indication of squint. Not a doubtful case.
The petitioner participated for recruitment in CAPF stuff. He was declared medically unfit by the it's DME, isn't it?
Yes, ma'am. Yeah. Detailed medical examination.
Unfit in the detailed medical examination.
And review medical examination.
The ground for such declaration grounds were defective distant vision in both eyes and squint. Stop. The petitioner had the option to apply for review medical examination. Had the option to apply for review medical examination, which was duly conducted, and the review medical examination board found that the petitioner had mild squint in the left eye. Stop. Being aggrieved by such a finding of the medical board, the petitioner got himself tested in a state government hospital where no squint could be detected. Stop. The petitioner again got himself tested in the AIIMS at Kollani, where also squint could not be detected. The petitioner submits that as two of the hospitals could not detect squint, the medical examination conducted by the DME board and the RME board are faulty and incorrect. Stop. Prayer has been made to permit the petitioner to be tested. No. For setting aside the finding of the medical boards of the CAPF authority. Stop. The learned advocate representing the respondents opposes the prayer of the petitioner. Stop. It has been submitted that the medical board clearly found that the petitioner was suffering from mild squint in the left eye and he is unfit for the job. Stop. The guidelines for rejection of a candidate have been placed, the guidelines for recruitment medical examination in CAPF have been placed before this court. Stop. One of the grounds for rejection is any degree of squint. Stop. It has been submitted that as the petitioner was detected with mild squint, accordingly, he cannot be recruited. Stop. I have heard the submission made on behalf of both the parties and have perused the materials placed before this court. Stop. The petitioner applied for a recruitment in CAPF. Stop. He was medically tested and examined by the detailed medical board and also by the review medical board. Stop. Though the detailed medical board found the petitioner to be unfit on two grounds, the review medical board found the petitioner to be unfit for one ground, that is mild squint in the left eye. Stop. According to the guidelines for recruitment, any degree of squint is a general ground for rejection of the candidature. Stop. Paragraph. Submission of the petitioner that he was tested by the State Government Hospital and thereafter at AIMS, and no squint could be found, will not come to the aid of the petitioner. Stop. As the petitioner was competing for recruitment in CAPF, the observation of the medical boards of CAPF will be the ultimate consideration. Step. The level of fitness required for appointment in CAPF may differ from the fitness level of a civilian. Step. The squint in a CAPF personnel is a ground, is a ground for rejection of his candidature. Stop. The as one of the grounds for rejection of the petitioner is mild squint. Accordingly, the prayer of the petitioner for appointment in CAPF, despite such observation by the DME and RME board, cannot be accepted. The writ petition fails and is hereby dismissed.
There was a judgment of the Supreme Court recently made. My lord, if my lord was dictating, I could not interrupt, my lord. In this matter also, similarly, a person was detected glaucoma by the DM and RME, and his candidature was rejected. But the Supreme Court held that the opinion of the AIMS would supersede over that, and thereafter he was considered for the recruitment, my lord. This is an unreported judgment. Civil Appeal number 7254 of 2025.
Which portion?
Madam, in this case, the court also, the Honorable Court also directed the AIMS to consider whether he was suffering from glaucoma or not, whether the duty is to such extent that it could be considered. Paragraph 4, madam, page 2. Instant matter came up for hearing on 16th May. Page presided over by one of us, the Honorable Judge, and the appellant was permitted to establish contact with so-and-so doctor. Once again, to ascertain whether the appellant is suffering from glaucoma or not. And even if he is found to suffer, whether it is of such extent to have a material bearing on his fitness to render service as a prospective member of the CFP. Pursuant to the direction, a report has been received from AIMS Delhi, dated 27 May 2025. Along with the report, there is an opinion dated 26 May 2025 rendered by the medical board comprising of 6 professors, assistant professors, associate professor, additional professor, senior field officer of the ophthalmology that there is no evidence of glaucoma on clinical examination of both eyes. In view of the above-mentioned report given by AIMS Delhi, one of the premier institutions of the country, it seems to us that the ground on which the appellant was held to be unfit no longer survives, and there being no other impediment, the appellant deserves to be considered for appointment as an assistant commandant in the CFC. Order according.
The petitioner refers to the judgment dated 29th May 2025 passed by the Honorable Supreme Court in Civil Appeal number takedown arising out of SLP number Ato Divyanshu Singh versus Union of India and others, wherein the court directed the candidate to be tested by an ophthalmologist of AIMS. But then, whether this ophthalmologist was of AIMS, that is not very clear.
But the honorable court referred to
A particular, no, the court directed the petitioner to get in contact with an ophthalmologist, right?
Yes, ma'am. Well, actually, what happened? This was second time reference to.
All right, report has been received from-
will show that one. With paragraph here, getting on 24th April 2024, the respondent number 2 released a notification for recruitment to the post of assistant commandant in the CAP. The appellant appeared for the examination and was declared selected under the general category by notification dated 24th September 2024. The appellant appeared for the physical test and qualified for the same. However, he was declared unfit during the medical test held on 18th
Ophthalmologist
May I?
of AIMS.
The only thing is that probably the only distinguishing factor is that general grounds of rejection does not say glaucoma. Probably from bare reading icons do not find the word glaucoma. Probably that is the difference between these two cases.
In this case, I am relying on the fact that this is an inexistent thing that they have described. Here also the same. Names medical board says there is no glaucoma.
Of AIMS to ascertain as to whether the candidate was suffering from glaucoma or not. Stop. ঠিক আছে? The
Page 81 and 82 gives the entire list of the writ petition.
the court.
May I submit this? Well, any disabling condition, the degree of which is in question. Well, I bow down. Then the authority of the CAPF and their hospitals will be there to judge who is correct for their force. Well, my lord, here the degree is not in question. There in question is the existence of the disabling condition itself.
কি বললাম? Last থেকে। The relying on the report produced by the medical board comprising of 6 professors / assistant professors / associate professors / additional professors / senior technical officer of ophthalmology, evidence of glaucoma could not be found. So, under such circumstances, the court directed the authority to call the candidate for interview. Stop paragraph. On a perusal of the general grounds for rejection, comma, it appears that glaucoma is not one of the conditions mentioned therein. Stop. The grounds for rejection mentions about squint and any degree of it. Stop. As squint has been detected, comma, the court does not think it fit to
My submission.
interfere with the decision of the medical boards of CAPF.
My submission with regard to existence of the disabling condition may kindly be recorded.
All right, I'll write it. Next.
Wait. Keep.
Yes.
We are for the respondent.
Respondents. None for the petitioner. Urgent for this week. Next.
কিছুতেই হচ্ছে না।
Five not this week লেখা রয়েছে না? Both sides. All right, yes.
And this is my affidavit. But the present petitioner used to work in the Calcutta Police. On 3rd of December 2022, a charge was made when he was in custody. The departmental proceedings was initiated, charge was framed. He was released on bail, my lord, in 22nd of January 2025. When he was in custody, the departmental proceedings commenced and certain witnesses were examined. Subsequent to that, on 9th of October 2025, a final order was passed for his dismissal. And in this way, during that period, your lordship, this present petitioner approached this honorable court, wherein the writ petition was withdrawn because due to some technical errors in the petition. Subsequent to that, this petitioner approached the appellate authority under the Kolkata Police Act, that is the Assistant Commissioner of Police. Accordingly,
listed to such in a way.
and on 22nd of December 2025, the appellate authority confirmed the order of dismissal. Against that, before your lordship, I have come here, lordship.
Please show me the orders.
My lord, the final order of the departmental proceeding.
So there's perhaps no scope of any interim order. They have come up against a termination order.
101.
101 and 105.
105.
He has been dismissed for service, my lord. There is perhaps no scope of any interim order, and I'll have to, my lord, show some documents, my lord, against the main point he has taken, my lord. He has taken only one or two main points in the.
That's my only condition.
Yes.
My only contention is this. During the pendency of a criminal case, can a dismissal order be passed?
Well, that has to be adjudicated, isn't it?
Yes, sir.
Then let him file affidavit. Please come. The petitioner was serving in the Kolkata Armed Police. He is aggrieved by the order of termination passed by the disciplinary authority affirmed by the appellate authority. Next. There is hardly any scope to pass interim order in this matter. Stop. The respondents are directed to file their affidavit in opposition within a period of 4 weeks. Reply, if any, within a fortnight thereafter. Stop. Liberty to mention the matter for hearing immediately on conclusion of the aforesaid time period. Service is taken on record. Next.
I am for the petition. I appear for respondent of 1 to 6. In this matter, I have filed for the pensionary benefit after death. Well, my husband was dead. He was the ex-MTS employee, and during the pendency of this writ petition, the concerned head authority from Faridabad, he sent a letter for compassionate appointment. But we have not applied for compassionate appointment, but they are sent. But we are happy that appointment. But during this pendency of that case, the regional office Kolkata does not allow us to fill that form. We have categorically follow the instruction and visit the regional office as per direction of the head office. They deny to fill the form and supply the relevant documents to the head office. We have informed the head office also, my lord, that is our P2. We have can on P2. We have informed the head office also, but they are after that they several times saying that the writ petition pending, and that's why we are not arranging for the compensation ground. Well, this and in this situation, I'm praying for the this writ petition. My lord, kindly dispose of. Otherwise, they cannot be grant the compensation benefit, my lord.
What benefit?
Compensation ground, my lord.
Compensate service.
Service, my lord. P1.
Service?
Yes, my lord.
Yeah, your prayer speaks about the retirement benefits.
Yes, my lord.
That is the repetition.
That is the
Thereafter, they sent a letter.
Who is for the petitioner?
Yes,
My lord.
he will say.
Yes.
I am for the petitioner. My lord. Yes, can kindly see my lord annexer T1, my lord.
Yes.
My lord, I am ready to withdraw or dispose of the petition because that petition is bound to compensation ground, my lord. That is the barrier to achieve the compensation ground, my lord. My lord, they several times said that the writ petition pending. During the pendency of the case, we cannot do anything. And
where is your application for compassionate appointment?
My lord, can application T1, page 9, my lord.
Can.
Yes, my lord. Your file can, my lord. Well, it was pending. It was never heard. But after the circumstances changed, my lord. Page 9, my lord.
When did your husband expire?
My lord, he expired on the 15 December 2024. Sorry, the marriage solemnized and date 2024. July 3rd July 2024.
Come to page 25 of your writ petition.
Yes, ma'am.
How did you submit this document?
My lord, I have applied for that post. Yes.
How have you submitted this document?
I think that application was allowed by the concerned head of authority, my lord. But in writ petition, I have no requirement extra. Actually, in writ petition, my lord, I have compensated. I have only the after death benefit. That may be compensated post. That may be pension.
That means you do not know what you want.
No, my lord, I know, my lord. That is the after death benefit, my lord. It may be compensated down, my lord.
What it may be.
My lord.
Sir, what is the matter?
Hello, this is the matter, my lord. This person, my lord, Atya Naskar, my lord, he joined, he joined, my lord, sometime in 5th of January 2012. Later on, my lord, he had married to, my lord, the petitioner, Reena Yasmin, and they had one son from Reena Yasmin. Subsequently, he divorced to Reena Yasmin and married to another lady, and thereafter that lady has also one son. Now, thereafter, he died in harness. Now, the question of claiming this benefit, death gratuity, and pension, that is the application here. My lord, I have made a computation, my lord, and if you lordship direct me to file a report.
No, you have made the computation. What is the relief that can be granted to the petitioner?
They are claiming the death gratuity and the pension. So that amount has been computed here. Now they have made a additional claim that is not in the petition. Prayer.
That is not in the prayer. I have checked the prayer. There is nothing as such. And did the other lady also apply for compassionate appointment?
That I will check, my lord. That I will check. But the amount has been computed and it has to be disbursed now. Now that amount is about, my lord, 8,20,080 is, my lord, the death gratuity, and then pension coming, my lord, 13,400 per month.
But then if the other lady also claims, then how can you give the entire thing?
Yes, that claim, the lady has claimed, my lord. Therefore, my lord, I am beseeching you, lord, my lord, I will file, my lord, short report on affidavit stating all these facts, my lord.
All right. Yes.
Number one is Reena Yasmin and Atya Naskar, no divorce file. No divorce was filed. As because, my lord, there are special marriage registered. Yes, my lord.
What?
As because, my lord, no divorce was filed as per my instruction, and my lord, they also supply the marriage register copy. That is the special marriage act.
Assuming there is no divorce, but this person being a Muslim, he had the right to marry more than once.
But my lord, if it was registered under Muslim marriage act, that he can. But under special marriage act, he can't, my lord.
Please come. The petitioner claims to be the widow of an employee who died in harness. Stop. The employee was governed by the Mohammedan law. Stop. He was in service with the Central Groundwater Board. Stop. The petitioner prays for terminal dues. Stop. The respondent authority is directed to file a report apropos the claim of the petitioner within a period of
2 weeks, my lord.
2 weeks. अच्छा डेटটা দিয়ে দিন তো 23rd of March. Release the matter on 7th April. It will be open for the petitioner to file exception to the report prior to the urgent date. Please don't fail the date. All right?
Yes, my lord.
May it please your lordship. My lord, I appear for the petition in item number 7, my lord.
Yes.
This, my lord, is my writ petition challenging the actions, the representations issued by the respondent in withholding my pension and pensionary benefits, my lord. I have been employed with the CISF, that is the respondent, on and from 90. If your lordship quickly I'll give you a brief backdrop, Malad. And since 1985, I've been working at CISF. Sometime in 2010, Malad, there was an inquiry against me, pursuant to which I was removed from service. Now, Malad, this inquiry was subsequently modified, and there was a compulsory retirement. My punishment was modified to compulsory retirement. Malad, whereafter, aggrieved by the said order, I filed a writ petition. In the writ petition, Malad, I was acquitted of all the allegations that were charged by the CISF upon me, and there was an explicit direction upon the respondent authorities to re-induct me into service, Malad. Now, the intervening period that is there, from the time that I was suspended from my services and I was removed from my services, and till the date I was reinstated into services, my lords, I was receiving pensionary benefits. Why, my lords? Because my removal for service was subsequently modified to compulsory retirement before the Honorable High Court intervened, my lords. Now, the difficulty is that I have superannuated, I have retired, my lords. Now, the respondent authorities are saying that the intervening period in which you received the pensionary benefits, you're liable to refund the same in order to get your pensionary benefits, my lords, after the superannuation. That is the sum and substance of my case, my lord.
Did you get your salary for the period that you were in suspension after the suspension order was withdrawn?
I was. No, my lords, I'm grateful for that query. I never got any back wages. I'd only got the pensionary benefits at the time. Now they are saying that you refund us those pensionary benefits and we'll not even give you the basic salary for that period.
Where is the communication?
My lord, your lordship will kindly first have, my lords, page 152, my lords, of my writ petition. This has been issued by the respondent number 2, my lord. Says you refund the pension and pensionary benefits received during the intervening period, my lords.
But I can see an order of page 149 of a division bench.
Yes,
it says that the writ petitioner shall not be entitled to any back wages, but all consequential benefit will be payable and made available to them.
Yes, but I'm not asking for back wages today. All that I'm asking is the subsequent pension and my pensionary benefits that accrue upon superannuation. I'm just seeking for that, my lord.
You are Deepak Srivastav.
My lord.
All areas prospectively from the date of imposition of penalty of reduction in pay, including calculation of terminal benefit, shall be affected. This is exactly what you are entitled to receive.
All arrears, it says, my lords, prospectively from the date of imposition. As on date, I am not getting my terminal benefits or my pensionary benefits, is why I have approached your lordship. Now, this is an absolute order without any conditions, my lords. Now, the respondent authority.
Excluding from reduction, including any areas excluded, and the calculation of shall also be available.
The respondent authorities have posed this order to be a conditional one, my lords. Your lordship will kindly conceive of a situation wherein I have been acquitted of all the allegations. I have been in the intervening period receiving the pensionary benefits. Now they are saying that since you've been reinstated, all the pensionary benefits is subject to refund. Only then will you get your terminal benefits. None of these allegations have been proved against me, my lords.
See, there is an order of the division bench. If you are aggrieved, then you can always challenge it before the higher forum. Now, whatever is there is there.
Lord, your lordship will kindly appreciate that 2010 there's an order passed against me by the commandant of the respondent, removing me from services. Now, that order is subsequently modified, saying that compulsory retirement. I was receiving my retirement benefits when the writ petition was going on. 2015, the learned single bench passes an order acquitting me of all the allegations, my lords. This is upheld by the division bench as well, pursuant to the appeal that was filed by the respondents. Now the respondents are interpreting the order in such a manner to say that you have to first refund us the back wage, the back pension benefits during the intervening period that you've received, and only then will we make payment of the terminal
Please
benefits.
show me the impugned order.
My lord, impugned order, the representations have been impugned, my lords. The order, if your lordship will kindly have the single benches order once, my lord. This starts
No,
with
no, you show me where there is a direction for you to refund.
my lord, your lordship will kindly have page 154, my lords.
Yes.
This is the order dated 16th June 2025, my lords.
Your ladyship.
On one hand, my lords, they've regularized my service.
155, I can see paragraph number 6. There is also a provision for adjustment of the terminal benefits. It is not only refund.
Refund stroke adjustment of terminal benefits, that is there, and pursuant to the communications that have been issued by them, my lords, your lordship will kindly have. There they say that you have to refund us this money. Only then will we make payment to you. Page 171. Page 171 your lordship will have. Paragraph 4 at page 171, my lord. What they are essentially saying, my lord,
Alright, yes.
Yes. May I just one last submission? Would it then construe, my lords, that 2010 to 2022, that is the date of suspension up to reinstatement, I will not be entitled to anything, despite the fact that I have been acquitted of all the charges that are there?
Sir, there is a division bench's order. If you are aggrieved, you should move up.
No,
Yes,
division
please.
bench does not bar me from receiving the pensionary benefits that I have already received during the intervening period. It just says that
Yeah,
no
let me
back
hear the
wages.
respondents. Please wait.
Yes,
Yes.
yes, Lord. I'm good.
My lord, first of all, my first submission is that this is a misconceived application only on the ground that my learned friend is merely misleading the court. The dismissal order was quashed by this honorable court, and removal from service to the compulsory retirement was transferred by the revisionary authority. So revisionary authority's order was challenged by them before this honorable court. Similarly, the revisionary authority's order when challenged, my lord, this honorable court, my lord, the learned single bench of this honorable court, clearly opined that I am of the opinion that the order of removal from service as modified to compulsory retirement needs to be interfered with. Accordingly, the order of removal from service dated 17 June such and such passed by the disciplinary authority is set aside. The respondents are directed to reinstate the petitioner with all continuity of service forthwith within a period of 4 weeks from the date of communication of this order. The disciplinary authority is also directed to impose a suitable lesser punishment upon the petitioner in terms of Rule 34 of CISF rules. Except these penalties under such and such rules, the petitioner shall not be entitled to any back wages, but all other consequential benefits will be available to the petitioner. In my opinion, the aforesaid punishment will be sufficient coercive measure for the petitioner and will also meet the end of justice. Well, this order was challenged before the Honorable Division Bench. During the pendency before the Honorable Division Bench, my lord, what happened? The authority accepted the order passed by the learned single judge. And my lord, the judgment and order dated 13/3/15 passed by the learned single judge, my lord, has been implemented and the petitioner was reinstated in the service with effect from 11/11/22. So from 13/5 to 11/11/22, my lord, he received all the retirement benefits because of compulsory retirement, and my lord, PPO was issued. He received pension during the period up to the date of reinstatement. So, my lord, he received the pension as well as the other retirement benefits. My lord, since there was liberty from the Honorable learned single judge, my lord, so, my lord, a punishment was imposed, reduction of pay by 2 stages for a period of 2 years with cumulative effect by order dated 22. My lord, a linear, less coercive punishment was given, my lord, and subsequently, my lord, in 2023 he joined duty, reinstatement, 24 he retired. So, my lord, the provisional pension was issued. During this period from the date of 2010 to 2022, he enjoyed pension, he enjoyed all the service benefits. And now,
what are the service benefits? Pension, he must be.
Pension, gratuity, everything.
Gratuity, everything. All
everything,
right.
leave encashment. Now, after this reinstatement, my lord, he is asking that no, this. After retirement in 2024, he is asking that that part should be deleted. The pension that has been paid to him is to be deleted. That, your lordship, will be pleased to come to page 171. This should be read with page 171. In this regard, you have been asked to refund pension and pensionary benefit received during compulsory retirement of service and submit pension papers through online Bhavishya portal to continue regular pension as because he has retired in 2024. In turn, on 7/7/25, you have submitted an application where it stated that the demand for refund of pension and other benefits received during intervening period be dropped in the interest of justice and equity and requested to process the pension without insisting on refunds. So it is a mercy petition.
Assuming, see, he has retired from service and he will be entitled to receive pensionary benefit. Some portion you have paid during that intervening period.
Yes.
When it was pending.
Yes.
Can it not be adjusted because that is.
Well, pension cannot be adjusted, gratuity can be adjusted, but how pension can be adjusted?
Figure. You make your calculation.
But that does not come, your lordship, kindly see.
No, it is, I can see that there is no codal provision to adjust the pension. It is mentioned and you see that.
2 years benefit, my lordship, kindly remember. Only 2 years, 22 to 24. That cannot come to that amount. Lord, because he has already taken in 2022, up to 2022, the entire retirement benefits.
Entire retirement benefits?
Means because he was compulsorily retired.
Yes.
So, that part is as good as regular retirement. So, he received all the benefits.
Yes.
Now, He is saying that the benefit that I have received during the
Earlier.
compulsory retirement period, that should be dropped. Because that should be unknown and a fresh payment should be made. How it is possible that dual benefit should be given to an employee?
May I
Is
reply
it
to
possible?
that?
And now he is secretly concealing all these things, and now he is saying that these are the issues. No.
No, I am
Actually,
never concealing
they have
anything, my lords.
now
All of
not-
these,
Please come. Pradeep.
may I, my lords? All these documents form a part of my writ petition. I do not intend to conceal anything, my lords. Your lordship will kindly have the
Petitioner.
single benches order and the division benches order, my lord.
Seeks, the petitioner is aggrieved by the direction passed by the authority on 5th September 2025, directing refund of the pension amount. And to submit pension paper through online Bhavishya portal for processing his regular pension. Stop. It appears that there is already an order passed by the Honorable Single Judge and by the Honorable Division Bench in this matter, where the court specifically directed that the petitioner would not be entitled to receive back wages, but all arrears, prospectively from the date of imposition of penalty of reduction of pay, including calculation of terminal benefits, shall be paid. Stop. The learned advocate for the petitioner contends that the authority ought not to direct the petitioner to refund the amount that he has already received on account of his pensionary benefit. Stop. The aforesaid submission of the petitioner is opposed by the respondents. Stop. It has been submitted that all pensionary benefit, including pension, gratuity, leave encashment, were disbursed in favor of the petitioner, and there is no scope for adjustment of the amount of pension already received by him. Paragraph. The issue has to be decided upon exchange of affidavits. Let affidavit in opposition be prepared and circulated within a period of 4 weeks. Reply, if any, within a fortnight thereafter. Liberty to mention the matter for hearing immediately on completion of the aforesaid time period. Service is taken on record.
I am so grateful, my lord.
This is mentioned in group 9, lordship. Kindly see the page number 1, lordship, mentioned in group 9, lordship.
Group 9 matter?
Maybe, lordship, kindly see, lordship. It's a challenge a caste certificate. Group 9 matter.
It's relating to group residuary. Residuary under group 2. Who mentioned? When?
Lordship, Thursday, lordship.
Thursday? Alright, Thursday. You please intimate your learned friend that it will appear as to be mentioned.
Lordship.
Item number 9. My lord, I am for the state, my lord, before my learned friend proceeds, my lord. My lord, the copy that has been served upon us is illegible beyond reading, my without prejudice to and P1, the annexure is missing, my lord. In my copy, that is page 23, my lord. Otherwise,
The Aadhaar card of the petitioner.
Yes, it might be, my lord. And P2, my lord, kindly see, my lord, how illegal if it is.
Says the server.
But otherwise, my lord,
downloaded from the server.
Yes, yes,
It
that
should come with the original copy, hard copy.
otherwise
Hard copy I have been served. I have twice notice has been served. Nothing, no question has been made.
Copy was filed in the
Yes,
GP office?
Yes.
Then where is that?
Both two copies has been filed.
Why will you not have? You must be having a copy.
I'm having, but I have not brought it.
Then that is something else. If you have not brought your brief, it's your problem.
That's a very, very urgent is the matter.
Very urgent. What is it?
Well, kindly straight away come page 24.
24.
Malad annexed P2, Malad is notification has been made by respondent number 5 is the SDO.
Yes.
Malad is said that Malad there is a Malad vacancy. Malad straight away come Malad second paragraph says Dubrajpur. Some post is Songho coordinator. Malad first column Malad Songho coordinator. Malad I am concerned with Malad bottom portion 1 2 3 4 5 4 from bottom Loba. Lordship got it, Malad.
One vacancy is there.
Loba, yes, one vacancy. Malad kindly then Malad kindly turn to page 28. Malad page 26 there is a Malad criteria who can apply it and Malad what is the age. Malad this has been happened. Malad page 20 straight away come. Malad there is Malad three things. Malad is the written complaint first. There is a computer test and the interview. Written complaint is 70 marks, 10 plus 20 plus 30 is Malad general knowledge, writing skills, and Malad it is all total 70 marks. Then next part is computer test. Malad is a 30. Malad is computer test, and then Malad interview. All total Malad 100 marks. Malad kindly see Malad examination date 1st of February. There is a time. Malad there is a type that লিখিত পরীক্ষার ধরন MCQ প্রতি নাম্বার 1 নাম্বার কোনো নেগেটিভ মার্কিং নেই. There is no negative mark. Then my lord, there is a আবেদন পত্র জমা দেওয়ার স্থান, and my lord, there is a next page. My lord, this is the entire notification. There is no cut off marks, nothing. So first there is a 70 marks written, 20 marks computer examining, 10 marks is the my lord interview. This is the total. My lord, page 30, I got the admit card. It's examination date. This is I sat in the examination. Then my lord, straight away come to page 36. This is the publication formula. This Songho coordination in connection with engagement post of Songho coordinator. This is called interview published for written exam on the basis of written examination. This is list for computer test. My name is not appearing.
So,
there is no cut of marks. But these marks had been calculated after Malad interview. Out of 70, maybe I got 2 marks.
Even then you have to
yes,
be...
no cut off marks.
What do you mean to say
yes,
cut off
yes,
marks?
There is no cut off marks. Well, kindly see the inter notification. But these marks should be calculated after interview.
And very crucially, Lordship will find there is no single demand of justice.
This is
that is clarified. No. Without rapid run, they should have.
Show me your entire list of candidates who appeared in the examination and the marks they received.
Nothing.
Then kindly direct so because we have already intimated them to come with the appropriate documents. Those are perhaps forthcoming, my lord. So kindly give a date.
Any day, my lord.
And my lord, already, my lord, that has been published. Everyone
challenge that.
Is not there, my lord. Everyone will come that.
Yes.
If the ground, we have not been given what marks.
Yes.
Everything.
Even I got
there must be a reasonable, at least a reasonable ground, my lord, for coming, my lord.
0 marks. Then I have to call, my lord.
Then everyone.
Yes.
Suppose somewhere, my lord, 2 lakhs of examining is sitting.
Yes.
Then everyone will come with a writ petition.
Cut off marks. Then you.
There must be. No one can come at it. Sir, allow me. No one can come at it fancy. And they could have directly gone to the demand of justice. My lord.
Page 36. This is published on 13th of February 2026.
2026.
And the date of the computer test was 21st of February 2026. You filed the writ petition on 25th. Why will it be entertained?
I got thereafter. I take a leave.
No, but then why will it be entertained? Because by the time you have come to court, the computer test has also been conducted. You should have come earlier.
How can I know? I filed on 24th. I got the leave, matter fixed, my lord, last Thursday. There is a holidays. Bench has been changed. I mentioned on Friday.
Nothing has been written in the writ petition.
Last week fixed in the today. But
That is all right, but then,
enter notification, no cut-off mark.
please come.
Absolutely, my lord, is
That is the cut-off line.
The matter relates to the recruitment process for engagement of Shangho coordinator.
My lord.
Through Shangho Samobai. Stop. The petitioner participated in the recruitment test, but her name has not been enlisted in the list of candidates qualified for computer test and interview. Stop. Submission of the petitioner is that as there is no cut-off marks for appearing in the computer test, accordingly, any candidate who participates in the recruitment process has to be called for the computer test. Stop. It appears that the notice disclosing the list of candidates qualified for computer test and interview was published on 13th of February 2026 and the date of the computer test was fixed on 21st of February 2026. Stop. The instant writ petition was filed on 25th of February 2026. Stop. By the time the writ petition was filed, the interview, the computer test was long over. Stop. Paragraph. Only for the purpose of ascertaining as to whether the ascertaining as to how for the purpose only to ascertain as to how candidates were selected for appearing in the computer test, the respondent authority is directed to file a report by 23rd of March 2026.
That is too late. Inter procedure will be
not even written to any of the authorities.
Why should I retain? Why should I retain? Why the mandatory procedure? Where is the mandatory procedure?
To appear in the list on 30th of March 2026.
Inter procedure will be.
Next, the
only for this post only one
only one post and so many candidates.
I'm not telling you other. I'm not telling you.
Everyone will be
Let me see.
30th long. Everything will be gone. Everything will be gone.
Kindly appreciate.
Make it 16th. 16th report. Report by 16th. Released on
it will be a shorter date.
18th. Released on 18th.
Entire thing will be gone, my lord. I'm telling you only one post.
Even if he has not come with
how can I know, my lord?
What
I call the next one.
What grievance he has come before the court? He could have.
Can it be, my lord, before that, my lord? After receiving it, after receiving the copy, they will be able to complete it in that thing, my lord. The service will be kept on record.
Appearing on behalf of the petitioner. Lordship, this matter pertains to a simple thing, Lordship. The petitioner was appointed as an RMO and clinical tutor in the Department of Ophthalmology Medical College on 24/3/2017. Lordship, after that, the petitioner was promoted as assistant professor of the said department in the year of 2021. In 2025, March 2025, the petitioner opted for resigning from the said post, and accordingly he submitted his resignation letter along with the formatted policies, which includes pro forma for application of resignation from service, which is annexed in page 16.
Your resignation is not being accepted.
Yes, not only accepted.
they have not given communicated anything that whether the resignation
Where is
accepted or not.
your application for resignation?
Page 14.
Page 14, Lordship.
Why don't you consider it and dispose it of?
Milord, the fact is that, Milord, as on date, the government is suffering from shortage of
Doctors.
recruitment process on, Milord, and simultaneously the resignation part is also being dealt with. And simultaneously, this resignation part is also being dealt with.
Dealt with means?
They're relieved one by one. But Milord, the recruitment process is also on, Milord, because we are suffering from severe shortage of doctors.
Lordship, 7 months.
If your Lordship so desires, Milord, your Lordship can direct respond number 2, Milord, to dispose of this application subject to compliance of all the formalities by the petitioner.
Why do you want to resign?
Lordship.
You want to go for private practice?
Nothing as such, Lordship.
Then why?
Nothing as Lordship.
You are a medical practitioner. The patients are waiting for services and you'll resign from the government service.
See the reason I have already stated that I am the only son of my parents.
Yes.
So there are no one else to look after them.
So you'll stay back at home and look after your parents.
Yes, Lordship, because
But yes,
who will look after them? They are above 65 years of age.
you need to sit at home to look after your parents.
There are no one else to support them, Lordship.
Tell me one thing, you will sit back at home and look after them. I'll restrain you from private practice. Will that be good?
No, Lordship.
Then you certainly want to resign and join private practice.
Lordship, it's been more than 7 months. Okay, if they don't want to give me the resignation, then they should communicate to us that what is the status that whether.
That is a different thing.
Yes,
First you
Lordship.
say what is the reason for resignation? Why do you want to resign?
Lordship, the basic reason is that we just want to.
The petitioner is what is your current position?
Assistant professor.
See, you are the assistant professor. How will new students learn if you do not teach them? You are not in regular service. You are a doctor. So you are to render service to the patients. See the condition of the government hospitals. And now if these doctors are permitted to resign, then how will the government hospital run?
We are already suffering from severe shortage of doctors.
The petitioner is serving as assistant professor of the Regional Institute of Ophthalmology, Medical College and Hospital. Stop. He tendered his resignation. When?
1/3/2025.
Where is it? Which page?
Lordship, it's page number 16, Lordship. Point number 11, date of formal notice for resignation.
On 1st of March 2025. The application is yet to be disposed of. Paragraph, learned advocate representing the state respondent submits upon instruction that currently there is huge scarcity of doctors in the hospital and it may not be possible to release the petitioner immediately. Stop paragraph. Be that as it may, as an application filed by the petitioner is pending consideration at the end of the Director of Medical Education and ex officio secretary. Who is going to consider?
This one number 2.
This one number 2.
Director of Medical Education. Accordingly, the instant writ petition stands disposed of by directing the respondent number 2 to consider and dispose of the application made by the petitioner seeking resignation in accordance with law at the earliest but positively within a period of 8 weeks from the date of communication of this order. Stop. It is made clear that the court has not entered into the merits of the prior of the petitioner and all points are left open to be decided by the aforesaid respondent at the time of consideration of the
Lordship,
petitioner's prayer.
may I be permitted to submit only one thing? Lordship, in the period of resignation, I have served the notice period, but they are also holding the salary for those, for the tenure of my resignation.
Acha. If any dues if the petitioner submits that the salary for the notice period is due and payable, stop. The authority shall consider the prayer of the petitioner for releasing his admitted dues in accordance with law. Writ petition disposed.
Grateful.
That I appear on behalf of the petitioner.
এতে একটা ট্যাগ লাগান তো।
You have sub, affidavit of service.
Your other side is not here, Mr. Bhattacharya.
Affidavit of service.
The affidavit of service will not serve the purpose today.
For these 2 days.
What to do? Next week or Wednesday?
Any one way, Wednesday.
Wednesday? All right. Wednesday. Just intimate your other side, then it will be easy for you.
Yes, yes.
Next.
Madam, 17, I appear for the petitioner.
Your other side? In case your other side is not there, then it will be on Wednesday.
I am for the petitioner, my lord, in 18.
Same. Wednesday.
Twenty, my lord, I am for the petitioner. But this is a matter. The petitioner is an employee of the National Textile Corporation. Now, there were certain mergers, and then ultimately the main point is resting on that Shagnik Sen, who's the petitioner, is in the marketing and retail division. Now, under him are different districts in West Bengal as well as Bhubaneswar and Patna all has been brought, and he was looking after it. Now, what has happened in one of the showrooms which were closed because National Textile Corporation is under very rough weather now. So it was closed, kept closed. Then the person who was running it on behalf of the company retired and all that. Then what happened? Khadims, which is a known name, in a way invaded into that showroom and broke open and started running their showroom. And that came to the notice of, was brought to the notice of this gentleman, on the 17th of May. And on the 18th, he lodged a police complaint to the Goriat Thana. Now, what has happened? The company has held him guilty of not looking after properly, as to not knowing when somebody is invading in this way. Now, this poor chap, he says he's suffering from cancer, he underwent treatment, all documents have been placed, and the most striking feature is that in my very short sojourn in the profession, I have never seen that when DP was initiated, an inquiry committee was held. The inquiry committee, after giving n number of clean chits, has come to the conclusion, not on the basis of any evidence. The officer clearly writes, I have no evidence. If at all this person is to be blamed, then there is collective responsibility, collective failure, but he should have seen it. And therefore, we are giving him major penalty. And what entails, stoppage of increment.
Where is the order?
The order is a one-page order. I am placing that order. The impugned order, is at page first 198, my lord, and thereafter 202. Both have been challenged. My lord, kindly take 198.
No, no use. Let them file opposition. Please come.
No, my lord, may I, my lord, today, my lord, I am not troubling, but may I, if you also once I can show, because the inquiry committee which was held, now this is I would suggest, place it in this way, my lord, subject to correction, rarest of rare circumstances, because I have been given clean sheet in all the charges. May I, my lord, with the lordship's kind permission, pay
And
for a
the
stay.
penalty is reduction of pay.
Yes, my lord, that is therefore, my lord, for period of 3 years with further direction that Sri Sagnik Sen will not earn the increment during the period and
by
such
the order of penalty imposed by the disciplinary authority and affirmed by the appellate authority. Stop. There is no scope for passing any interim order in this matter. Stop. Let affidavit in opposition be prepared and circulated within a period of 4 weeks. Reply, if any, within a fortnight thereafter. Stop liberty to mention the matter for hearing immediately on completion of the aforesaid time period.
I am obliged.
Taken on record.
But in 21, my lord, I am appearing for the petitioner, my lord.
Is your other side there? Wednesday.
I am deeply obliged. I am
Next.
grateful. Great.
You are appearing for the? All right.
Union of India, my lord, will not solve the authority. Is the ITI, my lord. This is, my lord, release of pensionary benefits, my lord. Earlier, my lord, bunch of writ petition has been disposed of, my lord. I will be praying for similar order.
And the ITI is the authority. Who appears?
Mr. Mukherjee, Bhattacharjee, Imon Bhattacharjee. I have intimated him.
Has he come?
Yes, he is in court. He is in court. I have today my junior had called him.
Section 19 is there.
See, your learned friend is relying upon an order and he prays for similar order. Right?
Bunch of
Go through it.
This is one of them. I will same author.
Go through it and let your other side come. I don't know.
Mandatory order.
I am not aware what the order is. I keep it on Wednesday.
Yes.
Wednesday.
Affidavit of service.
No, keep it with you. Next. Bring your other side. Next. Yes. 23, Wednesday.
24.
Wednesday. Dakun. Nobody, your other side is not there.
27.
I'm for the petition. Affidavit of service.
Petitioner.
Petition.
Yes.
This is my affidavit.
And for the respondents in this matter with Mr. Akshay.
Yes.
This is with regard to selection process of Constable GD of 2025. I have been, everything was completed, Your Lordship. I duly qualified in the physical standard test and physical eligibility test. Thereafter, medical examination was conducted. I was found to be fit. Now, Your Lordship, in the final list, I have been not. It's been found. I do not feature in the final list, and my selection has been found at page 27. Your Lordship will find this is the list of withheld candidates.
Your name is there?
Yes, at serial number 1270. 27, the last page.
27.
This is a portion of that.
All right. Are you ready with instructions?
My lord, something he has missed, my lord.
He has missed.
This, my lord, actually what happened, my lord? He went for a read earlier.
Yes.
That read was disposed of in his favor. Thereafter, my lord, in many cases we have preferred appeal. So, my lord, he should have been apprised a lot.
Appeal, I am not aware of that.
Many appeals issue has been settled. Are being filed or in the process of filing. My lord, let me take the instruction so that I can apply the lordship.
Listen, appeal is not the issue. Thing is, the page 27, his name is there in the default list. take instructions as to why in the withheld list his name is there. All right. The petitioner participated in the recruitment process for Constable GD. Stop. He is aggrieved as a GD in CAPF. Stop. He is aggrieved as his name has been published in the list of withheld candidates. Stop. The reason for withholding candidature is not disclosed. Stop. The respondent is directed to file a report disclosing the reason for withholding the candidature of the petitioner. Similar matters have been fixed when 23rd.
No, my lord. It was 23rd, but I prayed before
25th.
and I will be going to my ashram.
25th.
No, my lord.
16th.
I responded on 16th, my lord.
16th.
So 16th will be too much for me in all these matters, my lord. Let the matter come up after.
But then after 30th, in that case, the entire selection process will be over.
My lord, selection process.
But then your junior can always remain.
I will not say anything about my very busy person.
Instructions, your lordship. Well,
Not say anything. I will not. Fact is, my lord, as far
the instruction, then it will be much better.
As far as recruitment is concerned, my lord, the entire merit list was published on 15th and thereafter
15th of this last
January, my lord.
That means the process is over.
Almost over. Nothing is left. Still, my lord, whatever is there will be bought.
You want it on 30th?
31st.
31st. Acha, released on 31st.
Lordship, with regard
Yeah.
to withheld candidate,
March.
There are many candidates of such nature, my lord.
Lordship, one humble prayer with regard to withheld candidates, not further instruction, only the reason for which they have been withheld. So that report can be brought and that can be supplied within 16th if my lord places. Will not be a burden upon my learned senior friend.
Advocate is present if the respondent submits that the entire recruitment process is over and the list of and the merit list of selected candidates was published in January 2026. Released on the 31st of March. Let us see.
Lordship, my place can be candidate forwarded with Mr. R.C. Raghavan for all the respondents.
29 same matter.
29. Let it be called on serially, please. Is your other side there? Wednesday.
Service complete.
Keep it with you. 29, same order as 27.
Yes, yes, Your Lordship.
Same order as 27, service is there.
Item ta khali साथ असले.
Grateful, Your Lordship.
Thirty is also same.
No.
Who is your other side?
Not keeps it on Wednesday.
Wednesday.
Petitioner. Lord, on the last occasion, my lord was inquiring whether my lord service has been effected. My lord, it has been effected.
Who is the answering respondent?
My lord, the authorities, my lord,
Which
the private respondents are also there. My lord, the state government
State government is answering and private respondent is
are
also
also
there.
there. My lord, who have superseded me in promotion.
Oh, then Wednesday.
Very well, ma'am. Great. May my lord only put in my affidavit of service?
32, I am appearing on behalf of the petitioner.
PAPF.
PAPF, Your Lordship.
Wednesday.
Gratefully.
I am for the petition, my lord.
Your other side is not here. Come on, Wednesday.
I am for the
Hey, Daku.
Lordship, 36.
Not today and tomorrow.
Okay.
With my lord indulgence, I understand this is not the usual time to praying for leave. But my lord, under compelling circumstances, I'm praying for leave to move on very urgent application, my lord. First, my lord, this is a circuit matter. The petitioner is residing at Darjeeling. Second, my lord, the recruitment process.
Circuit bench is not there?
No, my lord. Because, my lord, the recruitment process is going on.
When is the next circuit?
My lord, there is from 16th, my lord.
Next Monday.
Yes, my lord. But the only difficulty is, my lord, the recruitment process is going on and I'm praying for an interim order, my lord. This is by the West Bengal Health Recruitment Board, my lord. Very short matter, my lord. Thereafter, as per your my lord's desire, can be send it back to the circuit bench if you, my lord, wish.
Why don't you file it over there? 16th is just next Monday, because any order passed over here, the file goes over there. It will take a lot of time.
Yes, my lord.
Your matter will be delayed.
And my lord, otherwise my matter will be infructuous.
Why?
My lord, the process is going on, my lord.
Yes.
I has been arbitrarily excluded, my lord, by the on the face of my lord the caste certificate, my lord. My lord, only
At which stage were you excluded? What is the stage?
my lord, the
When
stage is the recruitment process is now going.
No, recruitment process.
Panel has been passed, my lord. Panel has been passed. Now, my lord, I came to know, though I am a OBCA certificate holder, but now, my lord, they have treated me unreserved.
All right, I followed it. You go over there. Right now, no interim order and it cannot be done.
My lord, may I just
No, filing it over here, taking leave and then going there makes no sense. It's better you go over there. Yes, call the list.
Great.
37, I am for the petition.
Is your other side there? No.
Witnessed.
Wednesday. Wednesday की monthly list बेरोगे? Next.
For the petition.
Other side is not there.
41 other side. Okay, so.
তাহলে কল করে লাভ নেই কাগজ
For not to take any matter of any of in absence of any of the parties, my lord. Some matters are relating to the recruitment. Can it be shifted in the as per your lordship's suggestion? In the daily supplementary list, or otherwise your lordship will take up the.
Yes, these matters will be taken up on Wednesday because the other side is not there. What can be done? Got it? So these matters will remain in the same position. It will be taken up.
Yes. Only thing is in item number 65, I appear for the petitioners. I have been told that your ladyship has been pleased to allow the mentioning today.
Mentioning for what?
For upgradation from monthly list. Possibly.
Even if it is there, it will be put up in the list.
Very well,
Please keep a watch.
Very well.
It is not that in the absence of one party, it will be taken up.
No, of course, of course.
All right.
Very well.